But we're using this word cybercrime, and one of the questions we need to ask, and some of the readings I gave you for this week are really getting at this question, the readings on Aaron Swartz, which is what kinds of activity do we want to say is maybe harmless or even productive, sorts of hacking perhaps? What is perhaps a problem, but a problem that should be addressed through civil litigation, through regulation, in some way short of calling it a crime, and what kinds of activity is serious enough that we want to call it a crime? And why are we drawing that distinction? We're drawing that distinction because to call something a crime brings the full weight of the state to bear on the activity against an individual. And certainly from a liberal democratic perspective on civil liberties, this is where we want to be the most careful. Now, we recognize that we probably need some kind of criminal law. We probably need circumstances in which the full weight of the state is brought to bear against an individual. But we want to be careful about when that happens and how that happens. And one way to think about this is just to consider the possibility of some kind of harm existing between two private actors. And we might say, all right, there's this harm that possibly exists. How should the law, if at all, get involved in adjusting the risks of that harm and of perhaps mitigating or deterring one of the actors from engaging in conduct that would cause that harm to begin with? And the domains of law that I put up here, contract, property, and tort, are domains that we call private law. So for example, let's say that I am private actor 1 and I am supposed to deliver a truckload of bananas to you on next Wednesday, and you own a small grocery store. So we can enter into a contract that sets the terms of delivery and says how much you're going to pay me. And so let's say I fail to deliver. Now, there's a harm there, but it's the kind of harm that we would normally say, we don't want that to be a crime. We bring the weight of the state to bear. We're saying the state can take away somebody's property through fines or penalties, somebody's liberty through putting them in jail, and even in some circumstances, somebody's life through the death penalty. So life, liberty, and property, those key interests that we think civil liberties guard, well, we don't want the state impinging on those just because I failed to live up to my contract. What we want is a system of contract law that says, now you can sue me for money damages or for some other remedy under contract. So similarly with most disagreements about property, so I own a building, you're renting in the building, you break the toilet, who has to fix the toilet? Right? So property rules will come into play and contract rules will come into play, not criminal law usually. And similarly with tort. Tort law is the law of injuries, personal injuries. So I'm driving down the street, I forget to put my blinker on, you don't see me moving into the lane, cause a fender bender, I cause some damage to your car and maybe some injury to your neck. If it's just negligence, then probably we don't want that to be a crime. Probably we want to say, you can sue me in tort, you can recover your money damages. Now, if I'm driving recklessly, or if I am drunk or something like that and cause you serious injury, maybe then we're getting into conduct that we want to call criminal. And in a moment we'll go through some principles that would help us decide. So when we're talking about private law, it's private law, but the state is still involved. The law is created by legislatures, which is part of the state, and or by courts. And so the state is still involved in giving the legal underpinning of private law, and a constitution or a basic law in a liberal democracy is also involved at least in setting up the institutions like the legislature and the courts that allow the private law to be created and enforced, allow you to collect the remedy. but we're not bringing the full weight of the state to bear yet. So then we say, all right, at some point, we're more directly involving the state. At some point, some conduct is going to not merely be an issue of private law that the law is supporting, the state is supporting in that way, but the state is going to act directly on behalf of the people and prosecute this. So how do we decide that? And this is the article I gave you to read, or the chapter I gave you to read, on principles of criminalization. So if we can distill some of these principles, the first thing we're going to look at, and we've been touching on this a little bit in our discussion over the past few minutes, is the degree of harm. How much harm is really occurring? If I fail to deliver the load of bananas, there's some financial harm. And we don't consider that just trivial, but we don't tend to consider that the degree of harm that criminal law should punish. Whereas if I'm drunk and driving and results in a fatality, maybe we do. It's a more significant kind of harm. Impingement on autonomy is in many ways related to harm. To what degree is the conduct that we're seeking to address impinging on somebody else's freedom? The degree of shock to the public conscience. And now this one sounds kind of nebulous, and in a way it is. And really these principles of criminalization are not sort of scientific principles. They're kind of ideas of the way we make judgments about certain things. So, fail to deliver the bananas, I don't think we would generally consider that a shock to the public conscience. It happens. There could be all kinds of, legitimate reasons why I couldn't get the bananas to you on time. Or maybe even I was just lazy or I just neglected it. That's not great, but it's not so shocking. Whereas, murder, that still is something that we say that shocks our society in such a way that it's a more important thing. And then related to that are these two. One is the de minimis principle. We want to generally only criminalize something as a last resort. We first want to try to say that civil remedies provide kind of the first resort, because again, we're not bringing the full weight of the state to bear. If we have to get there, then we will go to criminal remedies. And then a kind of final question, and I put a question mark here. Does morality or concepts of morality come into play here? Some legal theorists say that, yes, the more immoral we consider, the more seriously immoral we consider some kind of conduct, the more likely society is going to want to call it criminal conduct and bear the weight and bring the weight of the state to bear on it. Other legal theorists say no, law and morality are really separate things and don't really directly relate to each other. So that's something you'd want to kind of consider for yourself, and the extent to which morality does play into whether we call something criminal or not. All right, so let's say that we have an inclination that some area of conduct should be covered by the criminal law. What then? So then there are some other principles about how we craft criminal law. And the first principle is one of definition and drafting. We want the criminal law to be as clear as it can be, because we want people to know what is prohibited, what is a crime, and what is acceptable, what is not a crime. Because we're bringing the weight of the state to bear against individuals, we want to have some confidence that we're only doing that when somebody has really knowingly violated something that we're calling criminal. And to do that, we have to have it written clearly. Now, you should note that obviously most of us haven't memorized all of the criminal law. And I've been practicing law for over 30 years. I haven't memorized all of the criminal law. No one could really exactly do that. And we do have a principle in Anglo-American law that ignorance of the law is no excuse. So the idea isn't necessarily that everyone's going to actually literally know all of the law, but you can know enough to know certain things that are prohibited, and you can know enough to get competent advice that can tell you in some domain in which you might act whether something is on the line of criminality or not. The rule of lenity is a related principle, which is the idea that a court, in applying criminal law against someone, should interpret it, if it's ambiguous, as in the most lenient way toward the accused as possible. And when we talk about the question of access in excess of authorization under the Computer Fraud and Abuse Act, which we're going to talk about in a few moments on this video, that's kind of a place where you might say there's an ambiguity. What does that term mean? And one way that courts are supposed to be interpreting, say if I've got two different possible interpretations and one is more favorable to the accused, I'm going to lean toward the one that's more favorable to the accused. And that in turn encourages legislatures to be as clear as they possibly can in their drafting. All right, potential for enforcement. It's not good to have criminal law on the books that is never enforced or very rarely enforced. That tends to undermine the rule of law and to foster a disrespect for the rule of law, and it also makes it unclear to people what is actually criminal and what is actually the kind of thing the state cares about and what kind of thing the state doesn't. So when we're in a live class about this kind of question, I would ask, can you think of some things where there are laws on the books that are not enforced or rarely enforced? And rightly so, I think one of the first things a lot of people think of is traffic laws, at least speed limits on certain highways. Now, speed limits aren't exactly a kind of criminal law. It's kind of somewhere between civil and criminal, but you could make a good argument that it really undermines the purpose of speed limits if the routine norm is everyone drives at least 10 miles an hour over and the cops aren't going to stop you. Another one people bring up, and rightly so, is marijuana law and the debate today in many states about legalizing marijuana. And part of the debate is, there is this law against possession and use of any quantity of marijuana still in some states and under federal law, but in general that is not enforced, or at least it's selectively enforced, which is even more of a problem. So it tends to be enforced more directly against low-income and minority communities and not enforced in white and higher income communities, and that creates a racial disparity as well. So we want a criminal law that is something that actually there's going to be some capacity to enforce. We have to think about the extent and the type of punishment, and you'd have to get here into deeper into theories of punishment. To what extent is the criminal law about retributive justice? Is the purpose of the criminal law punishment, or to what extent is it punishment? To what extent is the purpose of the criminal law about restorative justice and rehabilitating and restoring the person? So we have to think about that. And then really broadly, how consistent is this crime, this defined crime, with other areas of the law? Does it fit in reasonably well with private law, and does it fit in reasonably well with other areas of regulatory law? And here, let me go back to the example of driving while intoxicated or driving under the influence of alcohol. So there is a regulatory piece of that, which is part of getting your driver's license, which includes some education you have to have about driving under the influence and has the rules about DUI. There's private law there, because if you drive under the influence and you get into an accident and injure somebody, that private party could sue you for negligence. And then there's also criminal law, because at a certain level and certain number of offenses, it becomes more than just a mere traffic offense. It becomes a higher level of crime. And we could say, well, that fits pretty well together. There are different pieces of this that are trying to give different incentives for people to act in certain ways. So that's a bit of background on